non-citizens in the country illegally be considered part of the people when it comes to the Second Amendment? That's a question that the Seventh Circuit U.S. Court of Appeals had in front of them earlier this week, and we've got some of the highlights. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop. Be sure to like, subscribe, and hit that notification bell with The Center Square here on YouTube, waking you up each and every weekday morning with a live program and segments and news clips, not just from Illinois, but all across the country. So be sure to like, subscribe, and hit that notification bell for The Center Square. And get the headlines in your inbox at thecentersquare.com. So this case was pretty controversial. It's USA versus Heriberto Carbajal-Flores, and district court, federal district court, said that this non-citizen who was arrested with a firearm after allegedly shooting 7 times in what they said was defensive warning shots in the Chicago area, he challenged the charge, saying that recent Supreme Court precedents under Bruin gives him the ability to be considered the people and able to keep and bear arms. Well, the case argued in front of the Seventh Circuit U.S. Court of Appeals had attorneys for the government trying to say the lower court got it wrong, and attorneys for Flores saying that he is a member of the community, has been here a long time, has an American-born wife and American-born kids, and this crime was in self-defense, and he's part of the people when it comes to being considered part of the country, though he's not here legally. But if you go to the Seventh Circuit U.S. Court of Appeals YouTube page, you can listen to this in its entirety. I'm just going to pull some clips here, and we'll kind of play through this together a bit. But you had the government's attorney in front of the 3-judge panel of justices making their case as to why they think this case should be reversed for the lower court's decision, and the appeals court should uphold the law that they say prohibits illegal immigrants from having firearms.
The district court erred when it determined that Section 922G5A is unconstitutional as applied to this defendant, because first, there should be no as-applied challenges to 922G5, only facial challenges, which the district court properly upheld. And second, even if as-applied challenges are allowed, there is no question that 922G5 is constitutional as to this defendant. Here, specifically, the district court erred when it found defendant was nonviolent, when in fact the defendant shot a firearm 7 times at a passing car without provocation and tried to shoot at a second passing car shortly thereafter.
Ms. Steindorf, is there anything about the Supreme Court's decisions in Bruin or Rahimi that undermine this court's conclusion in Meza Rodriguez that some illegal aliens can fall within the plain text of the people?
I think that Bruin and Rahimi again emphasize that the Second Amendment right belongs to law-abiding citizens, repeatedly referred to the right as belonging to citizens or Americans.
So again, you kind of hear some of the distillation of the arguments that the government's making in saying that this individual, Flores, was not a law-abiding citizen. He's a non-citizen. So what exactly defines the people? More on that issue with the government's attorney up there in front of the appeals court.
We focus on the people. How does the Supreme Court's opinion in Vertigo Cures impact our analysis? There, I know the court was looking at the Fourth Amendment, but it defined and talked about people in terms of having a connection with the country, having a connection with the community. It did not talk about people in terms of citizens or Americans.
Yes, it did refer to those who are part of the political community or national community, just as Heller did in referring to the people as members of the political community. I think the distinction that we can make here would be the scope of the political community as we understand those individuals who have Second Amendment rights.
So again, what defines the people is an interesting thing I think the appeals court's going to have to tackle here in this question. But obviously this case, when it came out, last year at some time, it really made a lot of people in Illinois think, well, if a non-citizen is considered a person, an undocumented individual, according to a federal district judge, is considered a person, then why are Illinois residents required to have a firearm owner ID card in order to legally buy and possess firearms and ammunition, right? Why have to get a document to do that when a federal district judge says even undocumented people have a right to keep and bear arms? So this really is an interesting pivotal case that the appeals court heard. But obviously with these lawsuits against gun regulations, a lot of it's stemming from the New York State Rifle and Pistol Association versus Bruin precedent the U.S. Supreme Court had about text, history, and tradition, right? If you have to look at the text of the Second Amendment, does the law violate the plain face of that, right? A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. So once they match it up with the text, then they have to show history and tradition, right? Look at analogs, similar laws from the past, and how that works in. So the government says text and tradition are there.
It's the tradition of barring firearms possession by those individuals who have not demonstrated trustworthiness or loyalty to the government.
Yes, Your Honor, that is one of the government proffered kind of two historical traditions. One of them is, most evidenced by the loyalty laws. Those that will not, that are untrustworthy adherents to the law.
Now, the government's attorney, Tuesday, in front of the, it was Wednesday. What's today, Friday? Yeah, I'm losing track of days, guys. I apologize. Live to tape here. But on Wednesday, the government's attorney talked about the loyalty laws they used to prop up their argument that Flores should not be given the right of the people to keep and bear arms.
Specifically.
What about if the same law, though, is attempted to be utilized, say, in a G1 context, where we're talking about a dangerousness analysis versus a allegiance analysis? Does that present a problem?
I think that's where Rahimi teaches us that we're looking for principles of the laws. And so by the government proffering the loyalty laws, I take your question to be in both the G1 context and the G5 context. There is the common thread here of felons not abiding by the law and those unlawfully in the country, also, not authorized to be in the country. So because Rahimi teaches us to look at the principles of the historical tradition, certainly both can be proper analogs in both circumstances.
So again, looking at the text, history, and tradition of these things, the government says that they have it on their side. And plus, they say that Flores was a dangerous individual.
Does not apply to all non-citizens, as perhaps you could make the analogy to the category of the felon. And so here especially, I think categorically, it's appropriate, in the historical tradition supports being able to disarm that category of individuals. If there are no further questions, the government would request to reserve the remaining time for rebuttal.
So again,
that's fine. Thank you, Ms. Steindorf.
The government first up sharing their thoughts, saying they have the text, history, and tradition rights, that Flores is not here legally, they shouldn't be allowed to have a firearm or have the right of the people to keep and bear arms. The defense got up on Flores's behalf and said that he is part of the people. Dan, fire that clip off. Here we go.
Citizen kids, husband to a U.S. citizen wife, attending public schools in Chicago starting at the age of 10. He is part of the people. The government wants the test to be political community closely associated with U.S. citizenship and the electorate. They do this by selectively choosing descriptive rather than prescriptive phrases from Heller, Bruin, and Rahimi. But
Mr. Crispin, before you go too much further, can I just clarify, are you appealing and challenging both the facial and as applies, or are you focused on as applied?
Well, certainly
I know you're doing as applied. Are you also appealing the facial determination?
Yes.
Or I guess the government has appealed, but are you arguing that 920?
So essentially what that means is as applied to Flores, they're challenging it, but they're also challenging it on its face. So they're essentially saying that they want the appeals court to find the law unconstitutional for everybody, so that anybody who is in the country, legal or not, they're part of the community, then they are the people. So more from the defense talking about that issue of being the people.
In terms of the government's test, the government's test is not supported in terms of who is a member of the people, is not supported by case law. In terms of, as we mentioned, the Supreme Court has decided that undocumented folks have First Amendment protections, Fourth Amendment protections, Fifth Amendment protections when they have come within the United States and developed substantial ties. And yes, my client does have criminal convictions, but the nature of his criminal convictions were looked at by the district court, and they were not violent in nature. I mean, these reckless conduct misdemeanor convictions, possession of cannabis, driving on a suspended license, and obstruction identification are not reasons for someone to be stripped of their Second Amendment rights.
Can you just tell me what his sentencing exposure would be if we were to reverse the dismissal of the indictment?
I didn't capture that part, but I would imagine that, a felon with a firearm or somebody who's getting a firearm charge that would be a felony, it's going to be some time in prison. Another question to that issue here to the defense of Flores, asking whether or not non-citizens in the country illegally can have firearms and be part of the people with the right to keep and bear arms.
I wouldn't becoming a citizen or starting the process to be here legally be that exception here, or that out for the individuals?
Well, the process, this is where I think the amici and the government get it wrong. It's not that just someone can say, I want to be a citizen and then swear allegiance or start an...
So there is a process, right? And that process, is that enough when you start it to be considered part of the people and you're working towards your citizenship status? Again, something that the appeals court's asking about because they're considering that when they have this case decided. When? Who knows? Could be months. But the defense was asked about the shooting incident itself that Flores was arrested after.
In any event, was it really correct, do you think, to say that the circumstances of the possession of the gun on the night of the arrest were nonviolent? I mean, firing a gun in public at passing cars, even if the shots were meant as a warning, doesn't strike me as nonviolent. And we have certainly seen enough of this sort of thing where innocent people are literally mowed down.
The district court took a look at this. The district court had the full video in front of the court and took a look at all the circumstances surrounding that night. And stripping people of Second Amendment rights because of a criminal history or because they are not responsible are not reasons supported by case law, as Rahimi has shown.
Well, others may disagree with that, as why it's a controversy in the courts. But another question here before we wrap things up on this case.
Does it make any difference whatsoever that this was not his neighborhood?
Well, while he was living in Cicero during that period, he went to grammar school in Little Village. He lived in Little Village most of his life, and he continues to live in Little Village now. This idea that it was not his neighborhood is not taking all of his history into account. While he wasn't living in Little Village at that specific time, that's where he's from, and that's where he continues to live now.
So the question again from the defense is saying, hey, we need to throw this whole law out.
If you fall outside of the people and don't have the Second Amendment protection, if there are some individuals who fall outside of the people, then it can't be facially unconstitutional.
Well, we think that Bruin's first step talks about the conduct of an individual, and we think that the plain text of the Second Amendment can cover the conduct of an individual that's not part of the people. And then we move to...
So you think even if you're not part of the people that the Second Amendment protects, that you could still get Second Amendment protection?
Well, that's what they're ultimately arguing in court, and we'll see what the appeals court has to say about this issue. Updates on other gun challenges. No updates on the gun ban challenge in front of the 7th Circuit U.S. Court of Appeals. We're still waiting on a schedule, right? They've got the case after the district court, Judge Stephen McGlynn, found the law banning semi-automatic firearms and magazines over certain capacities in Illinois unconstitutional. The appeals court has that now. We're just waiting on a schedule. For the Viramontes case in Cook County, that's a gun ban challenge for Cook County that also includes the state's ban. Not really much going on there other than a note from when it was argued on November 12th in the appeals court. So we'll be looking for that. You've got the Beavis case versus Naperville. That's still in the Northern District, and it's got a long timeline here. Looks like April 30th. Discoveries needed May 7th, 2025. They'll have a status hearing. Disclosures due by May 16th. So on. It goes on from there with depositions and experts conducted by August 31st of 2025. So quite some time there. Also, you've got the various briefs that are due for the Schoenthal case. That has also come through. You've got the state and Cook County and their defense of the case of challenging the concealed carry prohibition on mass transit. So that's another case we're following as well. Lots going on in Illinois. All right, that's why you can wake up each and every weekday morning here with The Center Square. Get Illinois in Focus daily in your inbox. Subscribe to the newsletter at thecentersquare.com. Follow me anywhere. Just search Bishop on Air and you can stay updated throughout the day. Wake up with us each and every weekday morning here with Illinois in Focus daily.